Revocable living trust-based plans, my favorite technique. I receive calls often that start out, I need a will. When I ask, why do you think you need a will? The answer is, I just went through probate with my mom's estate and I don't want my family to go through that. Well, if that's your concern, you don't want a will-based estate plan because the only way the will works is to go through the probate process. My preferred estate planning technique is a revocable living trust. With a revocable living trust, you keep control. A fully funded trust avoids the probate process, both living and death probate. With a revocable living trust, you buy and sell your assets just as you do now. You can change, you can cancel the trust at any time. The trust is absolutely transparent. You control when you give up control of your property. You control with greater predictability and privacy to whom you give control of your assets and your person if you become disabled. During phase 3 of our plan, you control what you give, to whom you want, and the way that you want. Your plan's only limited by 3 things. What you want to do can't be illegal, immoral, or against public policy. The only other limitation on your planning is the creativity of your estate planning attorney in achieving your goals. Many times, I've been with other estate planning attorneys. Guy on my left will say, my clients always do X on distributing their assets. Attorney on my right will say, that's funny, all of my clients always do Y to distribute their assets. Estate planning's about options. If I tell you you can do X or do Y, which will you select? But if I tell you that your options include X, Y, Z, or A, B, C, D, or anything you can imagine, what option will you select then? The role of the estate planning attorney is to help clients determine their goals, help discover ways that they might achieve those goals. Clients can't get there if the estate planning attorney limits their choices to only 1 or 2 options. Our job is to identify the options. So what is a revocable living trust? A living trust is essentially a contract that you make with yourself to benefit yourself and your later beneficiaries. There are 3 people involved in the contract. You, the trust maker, which means the same as settlor, grantor, trustor, and many of the other terms that are used. I just think it's easier to relate to as a term. You make a trust, you're a trust maker. A trustee, which in most revocable living trust plans is the trust maker while they are alive and well. And then a beneficiary or beneficiaries. The living trust is designed to address all 3 phases of life: alive and well, alive but not so well, and when we've passed on to our greater reward. As a living document, it addresses our current needs, but it also addresses our disability. And this is a private determination with no court involvement or control by the court. You control that decision. You control to whom you give control when the time comes, and you control how your assets are to be used at that time. A trust, like a will, it's a set of instructions. Unlike a will, however, the revocable living trust is a private set of instructions, and it operates while you are alive. It's not an instrument of death. That's why we call it a living trust. It's a great tool for your personal planning goals. Catastrophic illness protection. Because remember, statistically, we're all more likely to become disabled in any given year. So with your revocable living trust, you set the rules for when you are considered disabled, how that determination is going to be made, and then what's to be done once it occurs. Remarriage protections. My wife said she understands the old saying that women grieve, men replace. And she said, I love you, I don't like my replacement. So we built in some remarriage protections into our plans. Creditor protection, not for you unfortunately, but for your later beneficiaries. The only way to get creditor protection for yourself is either an offshore asset protection trust or one of the domestic asset protection trusts that many states have enacted. But that's a much more complicated advanced estate planning technique than we are talking about today. That's a seminar all to itself on asset protection. Divorce protection. When one of your kids gets divorced, how do you want the assets you left handled? What distribution do you want? Remember, how I want, when I want, the way that I want. Values promotion. Maybe we build in an incentive to your plan so your beneficiaries move beyond trust baby treatment and support charity as well. Leave some personal instructions for your beneficiaries. Remember, I define the trust as a set of instructions. Think of the instructions this way. Those of us who have or had children, what did we do when we went out for an evening? We hired a babysitter. And before going out for the evening, we left the babysitter a set of instructions to follow. Now, while we were out, we could call back, modify those instructions if something changed. That set of instructions was to guide the babysitter for while we were out and not there. Set our expectations. What are our wishes for taking care of our loved ones? So we have a whole set of babysitting instructions. Those instructions for the babysitter being amendable, call back and change situation, that's like a revocable living trust. We can always change it. As our situation changes or our concerns change, we can amend the instructions left in the revocable living trust that guide our successor trustees. We're still in control of those instructions. Unfortunately, far too many people leave less babysitter instructions for when we go away forever than we do for when we go out for an evening.